Get started.
Filed a motion to sever counts, or in the alternative, to dismiss the third superseding indictment. Lil Durk has wanted to go to trial as soon as possible for the last year and a half, but it's been delayed constantly over his objection. Since the government added a bunch of new charges in other states, his lawyers are now asking to sever those counts so they can start the trial in August for the LA murder. His lawyers are pissed. They're saying this was all intentional, and they want to go to trial as soon as possible. All right, here we go. We got Drew Findling, Brian Steele, Christy O'Connor. I always forget Dirk got some crazy good lawyers, bro.
Yeah, he got
through his
bread.
attorneys, Drew Findling, Marissa, Brian Steele, Christy. Hereby files this motion to sever
Boy, he got the dream team, don't he?
counts
Shit.
1 and 6 from counts 2, 3, 4, and 5, the LA counts of the third superseding indictment. This severance is necessary so that Banks might have the August 20th, 2026 trial that he has been preparing for since October of 2024, and that the Sixth Amendment speedy trial provision guarantees him. Prosecutors filed that superseding indictment, adding a bunch of crimes from Chicago and Atlanta and a bunch of other states, right? The LA murder has been in there since the beginning. His lawyers are saying we want to go to trial just for the LA counts in August, like we're scheduled to do so, because it's going to get pushed back if they don't. Should court deny Mr. Banks' motion to sever counts, the inevitable delay in this trial date caused by the government's unreasonable 11th hour addition of significant new allegations requires dismissal of the indictment, which makes sense. Durk hasn't waived his right to a speedy trial. He wants a speedy trial. He's been asking for it. The delays have largely resulted from
See, he want to speedy trial. Everybody know why he want a speedy trial, but that actually might play against him. That actually might bite him in the ass.
the case
But
being designated as complex under the Federal Speedy Trial Act, the number of defendants, extensive discovery, and scheduling issues involving co-defendants, not because Durk waived his rights. For 19 months, Mr. Banks and his defense team have been preparing to defend against charges related to the August 2022 killing of SR in LA. Team Banks is prepared to proceed on those charges on August 20th as currently scheduled. This trial date that had been continued 3 times over Mr. Banks' objection, had his demand for a speedy trial carried the day, he would have had his day in court in October of last year, and right now he would be home with his family. Confidence. They're like, if this would have happened 8 months ago or whatever, he would be home right now. But alas, Mr. Banks did not receive the timely trial he demanded. And so, in the interim, the defense team continued its preparations in earnest, preparations based on government representations about the intended scope of its case.
So they thought with all that confidence, and they thought because they was big dog and they so used to really getting what they want. That's not how it worked, bro. He a killer. Durk is a killer, bro. And I'm not saying that like, you know what I'm saying? I'm not just saying that this is what Lil Durk told us. You know what I'm saying? So I agree. 100%.
And court rulings addressing the same. These efforts have included actively litigating the admissibility of 1. Regarding evidence of other bad acts, including the January 2022 killing of Stefan Mack in Chicago, quote-unquote the Chicago incident. 2. Certain of Mr. Banks' song lyrics. After multiple rounds of briefing and argument, the court tailored a carefully considered ruling on the lyric issue. After representing to the court in January that the United States Attorney's Office had turned over all discovery related to the Chicago murder, it had not. The government announced in February that it was taking the Chicago incident off the table. The defense and the court proceeded for months in reliance on that representation, along with an array of the other government representations about what other bad act evidence it would and would not seek to introduce at trial. So they're saying pretty much the state attorney's office has lied, specifically about the Chicago murder of Stefan Mack. They said they weren't going to include...
Because they could do what they want to do. They could do what they want to do. That's the whole shit about it. They say, yeah, we're not going to use it. Looked you dead in your face. Let you know, tell everybody we're not going to use it. Let y'all build y'all case up. Then came back and said, we lied. We're going to use it. What you going to do? You going to file a claim? That's out of here. They going to do what they want to do. It's bogus, but this is how they play. This is their game. This is the game he entered.
Yeah, in the indictment, and then they ended up doing it anyway. So they did lie, low-key. The government now attempts to undo all that the parties in the court have worked for. Less than 3 months before trial, it supersedes for a third time, reinserting the Chicago incident into the playing field, and adding inflammatory accusations it could have charged from the start, including an alleged attempted murder in Atlanta in 2019, the Atlanta incident, robbery, theft, and a multi-state drug trafficking operation. Further, the government now asserts that because it has superseded for a third time, all prior litigation on the music admissions has been naught. What?
So they got bodies on him in 3 states, Chicago, Atlanta, and Cali. This is deep. And the lawyers are trying to separate each state. So they trying to get, let's hurry up and get the LA bodies. Then they're going to work on the Atlanta bodies. So they trying to separate trying to break the case down in hopes to get small wins and he get away scotch-free. That's why they telling him, no, we ain't going to do. That's why prosecutors is playing games and using tricks up their sleeve because they know what they on. He got a real good team. They know what to do. You know what I'm saying? So that's what's happening.
I'm going to relitigate all the lyric shit, This is so grimy. They're trying to undo what has already been litigated. In two successful new supplemental notices, 37 and 40 pages long, respectively, it reserves the right to seek the admission of a significant amount of
But
previously
why is it
unnoticed
grimy
music.
though? I don't understand that part. How was that grimy? I don't get that. Lil Durk was out here. He was killing people, bro. He got songs about killing people. He said he wanted. He said he was going. He wanted to be the biggest gangster. He said in some multiple songs he gonna live will come with that. So what's the problem? Why is it grimy? He woke up today, went to work, and said, "I gotta lock up killers." And Lil Durk said, "Hey, I'm a killer," so now he's finna go lock up Lil Durk. What's the problem? That's what the prosecutor's job is.
Lyrics and videos. Regardless of whether this government gamemanship and effectiveness or something else altogether, what the government is doing here imperils the constitutional rights of a man who is presumed innocent but nevertheless languishes in jail. In situations like this, where a defendant would otherwise suffer such prejudice to a fundamental right, the law affords this court wide discretion to order separate trials of counts contained in the same indictment, and they cite the law. Mr. Banks requests that this court permit him to proceed to trial on the LA counts against which he has been working so hard to prepare a defense. And the alternative, if Mr. Banks is forced to defend against additional serious charges that the government could have, with due diligence, brought in the first instance, the government has in essence forced a continuance. Mr. Banks' speedy trial rights would then demand a dismissal of this case. Defense is saying the prosecution waited too long to add all these charges and shit, and they should have did it off rip. This case has been taking shape for almost 19 months. June 21st, 2023, the government is aware of redacted allegation that Mr. Banks funds OTF drug trafficking. October 17, 2024, the government issues its first indictment in the case. Kayvon Grant is the lead defendant. Mr. Banks is not charged yet. October 24th, Mr. Banks is charged by complaint and taken into custody. He has remained in custody ever since, including almost 5 months in segregated housing. Oh yeah, he was in like the shoe, I think, for months. Forgot about that. December 2024, the government raises the
Y'all let me know.
and its brief in support of detention. The brief cites a search warrant affidavit from Northern District of Illinois for the proposition of that Mr. Banks offered money for people to kill those responsible. The government gives him a batch of discovery in December 2024. Banks has been involved in criminal activity, including the shooting outside of Atlanta restaurant in February 2019, where they were shot multiple times. Fonnie Willis in Atlanta, it was a state case, dropped those charges. Some people commented the feds probably asked him to drop those charges. I don't think it was that.
What?
In fact, his lawyers even just said.
What you mean you don't think it was that? People got shot and killed. What do you mean you didn't think it was that? And then all of a sudden they bring it back up now. What do you mean? What else could it have been? I want to hear what he got to say.
The federal case started happening in 2023 at some point. But that does happen where state cases get dropped because the feds are like, yo, we're already investigating this. You don't have to do it.
Yeah, okay
Happened in
then.
the Epstein case. Like that property that Epstein had. Sorry, off topic. Trial gets set for October 2025. Mr. Banks moves to dismiss the first superseding indictment based on the government's presentation of false evidence to the grand jury. The government told the grand jury that lyrics contained in the song Wonderful Wayne and Jackie Boy constituted an after-the-fact commercialization of SR's death, in which Mr. Banks raps about his revenge on Quando Rondo, with the music that explicitly referenced audio from a news clip taken shortly after SR's murder. The government's read on these lyrics, however, is demonstrably false. The song was recorded 7 months before SR was shot and killed, and thus could not be commercialization of his murder.
Now that is a win that they had. I don't know how they pulled that off. I guess it was, one big coincidence. But they pulled that off, and that was a win that they had. I would give his team that for sure.
Yeah, they pretty much proved that wrong, and the government was like, oh shit, they're probably right, and just like dropped it. All counts in the second superseding indictment pertain to the August 22 LA shooting. The second superseding indictment removes the false allegation contained in the first about the meaning of his lyrics. Government sends a 404B notice about more songs. Aha, rumors, scoom his ass. Mr. Banks has not joined the government, and co-defense stipulation to continue trial from October to January, although it's granted over his objection.
And all those songs, we all know, he was telling on himself. Aha, rumors, that he was telling on himself 100%.
So delayed again 3 more months. When I saw
So
that,
they right on the
that
dot.
shit's getting delayed. Now his co-defendants start filing shit that they want to be severed from Durk. His co-defendants citing the spillover prejudice from evidence primarily concerns Mr. Banks, including the Chicago incident and proposed song lyrics. Then they point out in October his trial should have started here and he would have received a speedy trial, but he didn't. His lawyers then request all discovery from the Chicago incident. The person who's referred to as co-conspirator 6 passes away. So who they're talking about is Bezu here. He passed away last year. He was shot and killed in Chicago, and they were friends for years. Like, I'm pretty sure they were like best friends. Like, look at this old ass picture of them together. I mean, this is from at least 2012 or 2014, probably 2014, I think. It had lyrics from Who Wants Smoke, Go, and Block is Hot. no music videos, but he cites these songs as admissions. It's crazy, right? Lyrics are
Yeah.
admissions, and
And Zoo had no reason to even be out there anyway. You know what I'm saying? Zoo could have got the fuck on with like he should have, but to each his own. Rest in peace. You know what I'm saying? We're not disrespecting nobody, but Zoo, in my opinion, Zoo shouldn't have been out there. You know what I'm saying? For real, for real.
or I've stated my opinion on this. Lyrics must have a nexus. If someone gets shot by like a Glock switch and a Escalade, and then someone goes and raps about shooting someone with a Glock switch into an Escalade, then you can add it. But if the lyrics are vague about just shooting enemies and ops and shit, you can't add it, motherfucker. Now we're getting a little bit of a transcript from January here from a hearing. At the hearing, it asked the government whether it has provided the defense with both the notices of incidents, which would be considered 404B evidence. I think they're quoting the judge here. But what I want to ask the government is, I don't want this to be a moving target. Is there any doubt of this right now that the evidence related to 404B has been provided, that the incidents which listed in the motion and limine are like 10 different incidents that are disputed, has all that been disclosed? In response, government counsel represents that everything that the U.S. Attorney's Office has in connection with different events and 404B evidence has been produced, has been disclosed. Durk's lawyers take issue with that. The court reiterates, and in the meantime, I want the government to make sure that it's providing everything it currently has. That's what these prosecutors always do, bro. In the YSL case, they try to hold evidence as long as they can. I swear that shit's intentional. More songs, Hanging with Wolves, Block.
Of course it's intentional. That's their
He's
job.
quoted saying, I'm not addressing here a number of things that the government originally put forth in the notice because I would say based on the reply, the government's memoranda, that the government does not intend to offer several of those things. So in that sense, I think the government is much more given up on a number of points. The government does not correct or dispute the court's understanding. At the hearing, after the court expressed doubt that the evidence in the Chicago incident would be admissible, the government told the court they would not seek to admit it. They represented, we are not inclined at this time to introduce the evidence, so I think we're going to make it an easy issue. Damn. Okay, so that's about the whole Chicago murder that they ended up adding in June. The judge was like, I don't think they're going to add it anyway, and then the government agreed with them. But then they added it. The judge is also quoted saying, as an initial matter...
Didn't I just say that they could do what the hell they want to do? If they will say what they want to tell you, and then you built this case up, and then now look at them. They pinned in the corner. So they trying to work themselves out of it, but it's saying everything is being denied.
The government initially indicated that it intended to introduce evidence surrounding an incident that occurred in 2022 in Chicago. At the hearing, the government withdrew the evidence for consideration. The court also expressed its tentative view based on the briefing that it was inadmissible under Rule 44B or 43. The motion, therefore, is denied as moot as to the requested evidence. References to that incident will not be admissible without first obtaining the express permission of the court. The order goes on to address Mr. Banks' argument that the notice lacks the requisite specificity, noting that the government cannot be said to be sandbagging the defense by switching its relevant theories too close to trial. The order then addresses each proposed piece of evidence in turn and makes a number of admissibility rulings. So the judge even said they were sandbagging the defense about that Chicago murder of Stephon Mack, adding that in last minute. Look at this quote. I think this is from the judge, too. The severance motion certainly is not a trivial motion. However, obviously, it would have been considerably stronger had the Chicago evidence remained in the case. So the reason I haven't had a hearing on it yet, is because I wanted the record to be clear as to what additional evidence was going to be omitted and which was not. So the judge has already said on the record, a severance motion would be stronger with that Chicago case and the whole trial. And it's now in the whole trial. So a severance motion is strong in the court's eyes. February 10th, the government produces a discovery on the Atlanta incident. February 26th, the court denies Mr. Williams' motion to sever defendants, based in part of the government's representation regarding the Chicago incident. It reiterated, as counsel no doubt realized, the motion was considerably stronger before the government's withdrawal of the Chicago incident. This is crazy. But the Chicago incident is back in there now. Things were ruled on.
Because they're doing... I don't even know if I'm going to finish this video, because I'm gonna repeat myself. They're going to do what they want to do. Yeah, they gonna add Chicago. They might add some more Atlanta shit. Like, they're gonna add whatever they want to add. Is it right? Is it fair? No. But it's killing somebody fair. It's killing somebody right. It's stalking somebody through multiple states right. You see what I'm saying? So we gotta accept the fact, like, bro picked his path. You know what I'm saying? As much as we all love Durk music and shit, this is the path Durk picked. Now they talking about, oh, it's greasy. I can't believe they're doing this. They're adding on stuff. And did he do it? Yes or no? They're gonna try to, they know what their plan is, and they're gonna try to intervene within that. Period. In the story. That's what they're gonna try to do. This is court. They're playing ball right now.
Because of the government saying they're not going to add the Chicago murder. Banks has not joined the government in the co-defense stipulation and continued the trial from April to August. So Durk has not been wanting any of these delays. The government sends a warning to the defense they're going to do another indictment by June 3rd. I read a whole document on that. May 29th.
That's why he
a
wanted a
month
speedy
ago, the
trial.
government produced
See,
a
in the
large amount of
beginning, I
discovery.
didn't know.
In the
That's
face
why
of
he wanted a
August 20
speedy trial.
trial date, the government supersedes the indictment for a third time. Unlike the previous indictments, the third superseding indictment is not limited to August 22 LA incident. Instead, it alleges a sweeping racketeering enterprise that encompasses a broad array of previously uncharged or unnoticed conduct, including murder, attempted murder, robbery, theft, trafficking, and controlled substances, obstruction, attempted obstruction of justice, witness tampering. So they added a bunch of shit out of nowhere. 2 months before trial, when it's already been a year and a half since Durk was arrested.
Because that's what they do.
It alleges that Mr. Banks funded a multi-state drug trafficking enterprise in order to secure Banks' gang enterprise, quote-unquote, associates' loyalty and ensure their willingness to engage in acts of violence. June 24th, so literally 5 days ago, the government amends its disclosure regarding music emissions. It communicates that it no longer intended to use any video associated with Go, although its intent to use the audio apparently remains. It also adds excerpts from 2 songs, Never Before Noticed, Computer Murders, and Sing This Song, quote-unquote. Look at this funny-ass note right here, frying them. This is probably because what the government represented to be the song's official music video was instead an amateur YouTuber's mishmash of unrelated video footage set to the song's audio. So remember that whole thing where they added a piece of evidence about that song of news clippings and the audio? So it sounded way worse. It made Durk look like he put news clippings of Quando Rondo screaming at his song.
And they saying that was just like what
it
fans
looked way
did.
worse. It's a
Yeah.
fan edit. They put a fan edit in the indictment that wasn't made by Durk.
Yeah,
and they called it the official.
They did. That's a mess up. See, that's a fuck up on their end, and I think they forcing it on everything.
Music video are an explicit agreement. A superseding indictment does not operate to automatically restart the speedy trial clock. What they're saying is every time the superseding indictment starts, it doesn't start that clock over. In federal case, it's 70 days. I'm pretty sure it's 70 days if I can recall correctly. The court has wide latitude to grant a Rule 14 severance where a defendant is prejudiced by a joinder. Unless the LA counts are severed at trial from the other counts, there's substantial risk that Banks' speedy trial rights would have been imperiled by the government's delay in seeking and producing discovery related to the third superseding indictment. The burden to justify the delay rests on the government. The defense, for its part, can think of no good reason for the unfortunate series of decisions the government has made that led us here.
Yeah, I ain't gonna lie.
Take the treatment of the 2019 Atlanta incident. Although the incident has been squarely on the government's radar for the duration of this entire case, the government never even noticed its 404B, yet now, 19 months into Mr. Banks' confinement and prosecution less than 3 months before trial, the Atlanta incident is suddenly part of a common scheme with the LA incident. No doubt in its opposition of this motion, the government will argue that it's inseparable for the purpose of trial. Similarly perplexing is the government's treatment of the Chicago incident.
So yeah, we finna cut this because all they're trying to do right now. What they're doing is adding on shit to the case, and they're trying to say that's not, you can't do that, but you can do that because this is the court of law, and they're gonna add on. They're gonna say it was new evidence. Now they did claim they wasn't gonna do certain things, but then they turned around and said they are gonna charge him for it because he did it. When you do shit like this is what happens. But I just want to know what y'all feel about. How do y'all feel about this case? Is Durk gonna come home? Is he gonna beat this, or is he going to jail? I kind of feel iffy about it, obviously. But y'all let me know how y'all feel about it. Is Durk coming home or not? Thank you for tuning in to Evansville TV.